This is the Know Your Law series by Barefootlaw, a non-profit organization which uses digital innovation and technology to provide free legal information and guidance for all. For more information, visit www.barefootlaw.org.
Hello, welcome back to Know Your Law series. We are still on our edition for succession, frequently asked questions that come in from our beneficiaries. We are here with Timothy. I'll be just reading in a couple of questions that are coming through, and he'll help us elaborate and throw more insight on them. The question here is, how should property be distributed? My nephews were given just 2 rooms from my father's estate, and the stepmom got everything else. Yes.
That is a very interesting question. Number one, there is no standard about how a person should distribute their property. If it is their property, they are free to write a will. And when they write a will, they can distribute this property to whoever they like, as long as they are making sure that they take care of their dependents. So in the instance that you have just given us, where the sons were given rooms and the stepmother got a lot more, the law would have a very interesting take where, as long as the sons are still getting either what they needed, what they were depending on the father for, then it would not be so much of a challenge. Now the question comes in where the deceased person died intestate, and that means without a will. In that situation, then there are some other mechanisms of distributing the property, which will involve certain calculations, and these depend on the size of the family, they depend on who the members of the family are, and the like. But the fact that this person was a stepmother to the children has got no bearing on this, especially if she's legally married to the person who died.
Okay. What is the role of a legally married wife where the husband dies with or without a will, especially if some of the children are from different mothers?
All right, so in this instance, we have someone who's legally married. Yes. Now, if the husband dies without a will, that person, that wife, and it's vice versa if it's the wife with the will who dies and the husband, that spouse will be the first person who can be considered for letters of administration. They have priority. And according to the law, that is the Succession Act and the Administrator General's Act, that person may not even need to apply for letters of objection from the Administrator General's office. So a spouse of a deceased person can very easily get letters of administration to administer the estate. Now, if there is a will, then it is expected that that wife has been catered for in the will. Although they may not be the person who is given the authority to execute it, that does not invalidate the will at all. Now, in the scenario you gave, there are children both from within the marriage and without the marriage. The law does not make a distinction as to whether these children are from the marriage or not from the marriage. As long as they're the children of the person who passed away, these are considered children and they're entitled to benefit from the estate.
The next question is, can an heir leave the property that was given to him or her by virtue of being an heir to his or her children? Is it automatic that once the heir dies, his child or next heir takes over? Yes.
So it is a challenge that we actually face quite a lot in Uganda, and this is because oftentimes when a person passes away, the person who is supposed to administer the estate does not actually conclude with the process. Administration of an estate is actually the process through which the property of the deceased person is supposed to pass on to the people who are inheriting it. And oftentimes people just leave the situation the way it is. So what should ideally happen in the situation is that when the person passes away, the heir and the other beneficiaries of the estate are supposed to get the property in that estate. So if there's land, the land should be registered in the names of the people who are supposed to inherit it. Now, in the scenario you have given, the person still remained an heir, meaning the property was still registered in the names of the deceased person. It's a bit more complicated, but the short answer is yes. That person's heir can also inherit what this other person had inherited. And they would just have to go through the same processes of ensuring that they show that the original owner of the property had left it to this heir has passed away, and now this heir is going to inherit it. So we encourage that if you are inheriting, or if you are the heir to one estate of someone, you work hard and make sure that that person's property, their estate in essence, is passes on to all those people who have inherited from it, to save on the difficulties that are faced in trying to now do the double inheritance from 2 generations beforehand.
Okay. If my father had 3 legally married wives, do they each get shares of the property or the inheritance?
In Uganda, the only way one would have 3 legally married wives is if they were married customarily and the custom is polygamous, or if they were married religiously in an Islamic marriage. And if that is the case, then yes, all 3 of those wives are recognized and are expected to receive inheritance.
All right, we are just going to go a bit onto letters of administration and have a bit more insight on that as well, because questions were coming in from there. Do I need both a will and letters of administration to pass on my property or my belongings?
When a person dies, their property will pass on regardless of whether they have a will or not. The only question is whether it will pass on in the way they wanted or not. So if you want your property to pass on to specific particular people and you care about those people, it's important to have a will. And when you write that will and you happen to pass on, then the people you have mentioned in that will become the beneficiaries to your estate. The people who you have identified as the ones who you trust to distribute the property will be referred to as the executor or executors of your will.
Can letters of administration be transferred from one person to another? For example, if the family had died and the wife obtained letters of administration, can they be transferred to another person, say a child of the family, in case the wife also dies? So basically, can letters of administration be transferred from one family member to the next?
Letters of administration are not themselves gotten out of nowhere. One has to apply to court in order to get letters of administration. And this is the same thing with letters of probate. Now, letters of probate are that is the permission you get when you are the executor named in the will. Letters of administration are what you get if there's no will and you go to court to be allowed to administer the estate. So now, if the person who has the letters of administration passes away, another person with an interest will have to then apply to court, again, petition court, mentioning that the current administrator has passed away, or even if they have not passed away, maybe they are indisposed, maybe they are sick, or they decided they have to travel to another country, do some cheyo. Then another person can apply and say that, look, this person who is the administrator is not able to fulfill their duties, so therefore they apply to be made the administrators of the estate. So it's another application to court, usually through the way of a petition.
All right, thank you, Timothy, for that. If you have any inquiries, any questions, please leave them in the comments. Make sure to subscribe, hit the notification bell, and you'll be informed of our next videos. And also follow us at Barefootlaw Uganda on Twitter, Barefootlaw Uganda on Facebook, and on Instagram. Thank you.